Yeah, basically.
You do the Gallup first, which is for first. And you go on out of Nashville, which is for they really run together, haven't they?
Start.
It's all I can do to read my emails. You know, I wish I did Facebook to just kind of know what was going on with some people. Lose touch with.
Are we taking a break at some point, or what?
I was gonna ask that too.
Halfway through,
Okay.
or if you're dying, you know.
Who's
send a
gonna
signal,
call
have a red
that?
flag.
Okay.
We can take a break.
No worries.
Todd, another question. Under the D, is there a reason why we couldn't probably add?
They'll be like, what does that mean? And then all of a sudden the agents have to go, well, that means, you know, da-da-da-da. So they're kind of giving advice at that point.
I just thought it was like the agency that had the points of each thing, what
Yeah.
agency means.
Yeah.
Because I had, talked to some title companies at best, they can't get a hold of the
I
buyer,
don't see 205.
best or guessing.
Yeah, that's true. We wind up guessing sometimes.
You see.
For sure. Well, where we get involved with is, you know, like I said, you got mom and dad and the kids, the son-in-law and daughter, all four buying a house.
Mm-hmm.
That's the intention.
Yeah. You guys ready to go on?
Yeah.
Yep,
Ready to go?
yep. Mm-hmm.
Good.
We're good?
Alright.
No, no, 203 isn't in here.
And that's not in there.
Well, I got a 203.
Bobby, I think that I've seen the camera.
Additional. Oh, you got rid of it?
Okay, yeah, they're in the order that's on the table of contents, so they're not in number order. They're in the order that we
Should
decided.
have had this instead.
Oh, they're
Where
not
is
in,
it?
This is the order that we have on the smart sheet. They're in this order.
this,
Yes, yes.
so you'll see what's in the book and these orders here.
In the page right
Like
there.
this, right? Yeah, got it.
I don't wanna be doing this while I'm gonna deal with it. He's just.
How long is this supposed to last?
We're scheduled until noon. If we need all that time, if we don't go that long, then we'll shut it down.
Are they able to ask questions from the,
Don't hold the speaker system, she'll be able to hear them.
So two.
When you guys speak to the microphone, she'll hear you.
these are all live? So be careful who we talk about.
Right,
Come on.
that's right.
It's okay, we can always shut it off back in there.
Okay,
It's gonna be a little hard cut.
can you
Is there a
bleep it out?
delay or something in case?
Yeah, you should, take a little bit of a delay.
You have a 5-second delay where you
Is it time?
Yep.
No.
There's gotta be a delay, it's gotta somehow catch up.
That sounded stupid. Got it.
Nothing's instantaneous yet on that.
Yeah.
Okay.
Oh, well.
Is this our class?
Yes, yes.
We were so worried that not everybody would show, we wouldn't have any
Parking
parking
places,
spots.
yeah.
And it was full signups, 12 people signed up, so we were even accounting for 2 no-shows, so it's still this empty.
Okay. Ready? Okay, good morning. My name is Bobby Noreen, and I am the chair, or was the chair of the Forms Committee for 2017. I'd like to introduce the rest of us at this panel table. And we have Todd Scholler, who is an attorney, has been an attorney and a closing attorney, but attorney for Tennessee Realtors for, gosh, quite a long time. Years and years? 15 years.
Something like that.
Yeah, amazing. So you've seen the forms evolve as well as you, Mr. Poe,
Yes.
Ron Poe, from the Memphis area.
Yes, thank you.
And how long have you been on the Forms Committee?
Not as long as Todd, just 14.
14. Well, you know, we'll have to defer to Todd then.
That's right. He's definitely senior.
Oh, yeah.
On my right is Denise Cresswell, who has been a very, very formidable vice chair and soon to step into the 2018 role as chair of the Forms Committee. So we're going to sit here and take responsibility for the entire committee, which is, 12 of us from all across the state, who decided to really delve deeply into the forms and not just change for the sake of change, but to clean up and clarify and sort of make sure that it was understandable to agents across the state, no matter what particular county or way of doing business. So our motive was not to just make changes because we could, but to make changes based on what we thought would make it much more understandable and clarify for experienced agents as well as new agents. So having said that, you'll see that it seems as if we made a lot of changes to a lot of forms, but some of them are very minor and will be very easily recognized as to why we did those changes. So getting started right away, you have before you a book with the forms that we actually did make the changes on, and those are in red line, what we call a red line version. The red line, or the red sentences, have been the ones that we've eliminated. And the blue, as you'll see, is what we added. So let's get started, and the first one we're going to do in the first few are so minor that I don't think it's going to take a lot. So if you go to the 101, which is dealing with listings, your exclusive right to sell listing agreement, is everybody with me? You'll see on page 6, on line 295, what we did is we eliminated the word sale and entered listing. Does anybody have a problem? Oh, good. Moving right along. We did that, as you can see, on the, that was the 101. We did it on the 102, which is the next one, page 6. If you look at 294, again, just since we were dealing with the listings, we believed that it should state listing and not sale. Okay, and then we did the same on the 131, which is in your book, which is page 7, line 320. And again on page 7, on the 132, I'm sorry, page 29 in your booklet, but it's this page 7 of the actual form. For the sake of those that are watching rather than being here, they're going to be looking at the forms, or what is it that they're seeing on their screens? Hi, everybody.
Yeah, I guess they don't have the forms in front of them if they're just watching on YouTube.
I see. So when I say this, I better slow up a little bit.
Yeah.
Okay. For you at home or in your pajamas, we are going through the first few forms that deal with listings. And the only thing we're changing is the word sale of real property to listing of real property to make it more cohesive with the actual form. So have no fear, we're going to dig deeper shortly. All right, so that takes us through 132. And we've got the Tennessee residential property exemption disclosure. no, residential, sorry. We're looking right now at the RF 201, which is the Tennessee Residential Property Condition Disclosure. Okay? So that would be your 201. We did add to the 201 on page 4 of the 201, or page 34 for those of you with the book. Sorry, I just realized that we got two different audiences following at different pages. So anyway, if you look at page 4 of the Tennessee Residential Property Disclosure, line 153. If you recall, we removed a lot of things last year out of the property condition disclosure, mainly because, as the attorneys informed us, the state of Tennessee did not require all of the things that we had entered for our sake. Therefore, we had involved our sellers in a higher risk situation. So we took those out, but we felt that there was a lot of pushback on that, and we felt that this is the property serviced by a fire department. If yes, in what fire department service area is that property located? And I think a lot of that, if you back me up, was for insurance purposes as well. Or what was our reason for adding that fire one back? Do you remember?
Yeah, insurance, liability.
Okay, so just so you know, that hasn't been added to the property condition disclosure. Any questions?
So you said that was added because of what?
Well, we felt that this is something that buyers insurance companies need to know, and so we had the seller disclosing it for the sake of the buyers being able to get their insurance ordered quickly and identified. Okay. But keep in mind, that's not necessarily required, but it is on our form. Okay? Then the next one that we are dealing with is the 205. The Tennessee Residential Property, it used to say Tennessee Additional Required Residential Disclosure, which we believed was a confusing title, where the agents would go in and not sure what that one was for. And what this one is for is, if you are exempt, and it says this, we put in parentheses, for exempt properties and property residential disclaimers. So in other words, we wanted to really identify that if you are exempt, you still are never exempt from these 6 items of having to disclose. So it was really important, and you'll see, and I think we should probably just do with that, what we did on 203 while we're talking about it. What we did is we realized that people are having the exemption filled out, declaring or the why they are exempt, okay? And if you recall on the exemption, which is the 203, and I believe it is in your, it's 8689. We can do that together because I think these go together. So you at home or in your offices, if you would pull the 203, which is your Tennessee Residential Property Condition Exemption Notification, that is what we've been using consistently, and even stating that it is a mandatory form that anyone who is exempt must fill out and send over to a potential buyer. However, this really is not required as an exemption statement. Is that correct? Can you back me on this? The Tennessee Real Estate Commission does not require that an exemption form stating why you're exempt is sent and needing signatures. So, having said that, we realized that the only thing an exempt person must do is this 203, if you keep it, which is this 6 additional. So if you recall on the page 3, I'm trying to make this as easy as possible. On page 3 of the exemption, we had included those 6 items. That's what made the form mandatory. But we found with a lot of builders, the builders didn't want to sign this because they said, we don't need to sign an exemption, we are exempt. So we took all of those 6 out of this 203 and made it a declaration page. In other words, if you can look at the bottom, we only have the seller's signature. It isn't required to have the buyer's signature, so we removed it. So this exemption form is really just a declaration by a seller stating that they're exempt and why. But it is not a mandatory form, is that correct, attorneys? So it's a good idea, and I think it helps us as agents because it has every box or category that would make you or consider you exempt. But it's not a mandatory form, but we left it because we thought a seller could declare it. And then we got rid of what's mandatory, so therefore you have this form, which is the 205, on page 37 in your booklet, and we've renamed it the Tennessee Residential Property Disclosure, and we put in here for exempt properties and property residential disclaimers, meaning those who are not going to fill out an exemption because they are exempt, or they're doing a disclaimer as an as-is property where they don't desire to fill one out, then they would, by the Tennessee real estate law, have to do this page. So no one is ever exempt from disclosing these 6 items on the 205. I'm anxious to hear those here. Do you have any questions? Is that clear, or did I just muddy that up even worse?
So to clarify,
Yes, thank you.
you just said if someone is selling it as is property, no one is ever exempt from disclosing anything. So if an agent is selling an as is property, the seller would fill out RF 205
Correct.
and forego the RF 203. Or fill out the 203 and just sign it and add that as part of the documentation that they send
Correct.
out to the buyer.
Correct. And let me say one thing about the as-is, as I understand it. If you are doing a property residential disclaimer because you want to sell as-is, that's acceptable unless the buyer requests a property condition disclosure, because the disclaimer and as-is would only be for sellers who are not exempt.
Right, okay.
It wouldn't be for exempt. So there's that one caveat where a non-exempt seller could not have to do a property condition disclosure, but only if the buyer was in agreement with it.
Right,
They still have to do this, though.
right, okay. And then in reference to builders, you said that they felt like they didn't need to fill that form out because,
They don't have to.
right, so in that situation,
They still have this. They still have to have the 205, you're correct. And what I'm finding with a lot of builders is they're incorporating this in their builder contracts. So you don't necessarily have to use this as long as they're disclosing it in their contract.
okay.
So we need to educate that they need to look for that if they're dealing with the builder. If not, then they would, the builder would have to disclose this.
And their contract should have these 6 items in
Yes.
there. Sometimes you have to hunt and peck in their contracts
I
to
know.
find everything.
Right. This is kind of a bigger change, and it came because I had quite a confrontation with a builder rep declaring that I was right, that they did have to sign an exemption, and they said I was wrong, and that was a shock. And so I quickly called our attorneys who said, yes, you are wrong. And so I had to realize that this exemption form as it stood was not a mandatory form, this one is. But I think the other's a good idea with
It's a great
the,
idea.
to keep it. So that's why it's more of a declaration with one signature than it is a 2-signature agreement. Okay? Yes, ma'am.
I was just gonna say, it gets a little confusing, but keep in mind, the Tennessee legislature enacted the property condition disclosure. And in creating the statute, they listed certain exemptions. If you exemption category, you are not required to do it. Through the Forms Committee, we created what is being referred to as the Form 203, which is the conditions notification, exemption notification, just to keep the market clear that, oh, this one is exempt. That's why we don't have it, because we have this other form, and it's just listing what the statute requires. Then when you flow back to the 205 we're discussing today, the form is the legislature in other provisions have said, notwithstanding whether you're exempt or you're required or not, everybody needs to disclose this stuff.
Right.
These 6 items.
So that's just a little bit of education that I think we really have to take back. And I think it's also important that the agents using these forms are speaking correctly to their sellers when they're saying this is the law, or this is, when it isn't. And I want to make sure that we're not quoting things that just because we think they are doesn't mean they are. So that was the point of that. Any more questions? Okay. So then moving on to the RF 651, which is the counteroffer. For those of you in the room, it's page 39. For those of you out in the world, it is the counteroffer, the RF 651. And what we did, and we did this on several of our various forms, is we have reworked or restated what it means to have binding, or the binding agreement. So if you look on page 1 of the counteroffer, down at line 43, it says, notice of acceptance of final offer was received by. So we were trying to really hit home the idea that the person that puts this date in is the one who had the final acceptance delivered to them, not the person who signed the final, or had the final acceptance. And that seems to be causing a great deal of angst out in the world. So we thought by saying received by, it would indicate that it needs to be signed by the person who receives it.
Notice of acceptance, the licensee receiving the final acceptance is the word. So this is just a mechanism in which to make it a little, hopefully make it a little clearer who's supposed to fill this in, which seems to be
That seems to be a tough
flying high most of the time.
We've only had that in there about 15 years, as I recall, in terms of the time agreement thing. But no, it's always confusing, and it remains confusing. So this hopefully will help.
Hopefully. And it is also something that really gets me is when people or agents say, I'm binding the contract. We don't bind, agents don't bind the contract. We just note the date we received, and that becomes the binding date. So is a contract, I'm going to ask this question, is a contract bound if an agent does receive it but doesn't put a date in here?
My position has always been yes, because I mean, really, the binding agreement date is just a label that we sort of tag onto an event that happened. And that event was, there was an offer, there was acceptance, and there was communication of acceptance in a set format, one of those 5 ways that we determined in the contract, and it was in fact received. At that point, I think you've got a contract, because you've got all the elements. We tag it with a name so that we have something to refer to, and so we can count our days from in terms of calculating time periods. But I think you still have a contract, but notating that when that event occurred is important so that there's no confusion about those calculations. So that's why I think it's always so important to make sure it's right. But it has been it's a point of confusion, and people get upset about it, and the wrong person binds it or whatever. At the end of the day, the question is, do we know when all of those events occurred? And that's where we go from. So this was our effort at trying to, get that across to the membership. So hopefully we did that.
I hope so. Thank you, Todd.
one thing that I found is a lot of times agents, especially after hours, when you're working with another agent, and the agent says, hey, we have an accepted offer, everything is signed, do you want me to go ahead and sign this? Because it's easier for me to just go ahead and send it back to you with the date already in place, rather than sending it to the person who receives the offer, puts in the date and send it back. And that's been an argument with a lot of my agents is, this is the way we're supposed to do it. However, that situation happens
But
quite
that could
often.
make a real big difference in a
Exactly.
day, and
Yes.
especially on a weekend
Yes.
rolling. It could
Yes.
change the whole
Exactly.
terms of when the
Home inspection.
inspections
Yeah,
and everything
exactly.
are. And so that, we really have to work on this, even though it's more convenient, it doesn't show delivery.
Right.
And that could really mess it up if we had to defend them.
And at the same time, we're looking at taking care of our clients. You know, what's in the best interest of them. It's not, you know, comfort on our part. That's part of our job.
As I said, everything's okay until it isn't.
Yeah.
But
Yes.
if they have not, if the other agent receiving this does not sign this, but they send the email stating that it was received,
That's your.
in my opinion, non-legal opinion, it becomes binding then, correct?
That's your proof of receipt. And I think if push came to shove and you were in court trying to show when something occurred, you would look at that date when they acknowledge receipt, despite the fact that they may not have notated it, our binding agreement date in a document. I think that's what a court would look to and say,
I had that conversation just this past week.
Yeah, yeah, and it, like I said, it's, I always think, how is this gonna look when I'm in court? And that's what, hopefully you never go there, but.
Keep one element in mind is that we've got two things basic we're working with. One is in basic contract law, as we know, offer acceptance, notice of acceptance. In the purchase and sale agreement, we allow for a very limited purpose for the agent to receive notice on behalf of the buyer or the seller. So that's the first established test. You've got the authority to receive that notice, because without that language in the purchase and sale agreement, you wouldn't have the authority. The notice would not be effective until it actually was delivered to the buyer or the seller, whoever the final counteroffer is coming from. So when you have the notice authorization where the agent can do, then you turn to Section 14A of the purchase and sale agreement, where it talks about the binding effect. Basically, the very last sentence there says, the parties hereby authorize either licensee to insert the time and date of receipt of the notice of acceptance of the final offer. So really, the agents, the licensees are only doing a proverbial act of dating something that's factual, not the date they think. And only, if you think about it, only the person that's received that notice would have the information and knowledge to be able to date it. Yeah.
And I really think, I know you out there and you in this room, we have to go out and really be the spokespersons to educate, because this is one I think that's really not being used correctly. And so any education would be really, really helpful. If you go to the 652, this would be a counteroffer on a lease agreement. We just did the same thing. On the bottom of page 40, we just clarified it on that as well. So there's nothing different on that. So on the 656, which is your notification, and that would be in here in this room, page 42. This is a wonderful form, and it's not gotten a lot of publicity, but we're really trying to push it as a usable daily, if not throughout the entire transaction, means of notifying the various required notifications due to buyers and sellers. Last year we had put it in categories. Page 1 says notifications from buyer to sellers up at the top, line number 6. And then you get down to page 2, line 68, and we have put notifications from seller to buyer. So they're not just mixed up, they're in some sort of order when you're looking. But if you go to the last page 3, we have inserted what we think is very, very important. And Holder, if we read that together on 97, Holder has advised that the earnest money, trust money, check, or other instrument has been dishonored or not timely received. Seller is hereby notifying buyer that buyer has 1 day to deliver earnest money, trust money, and immediately available funds to Holder. that is in the 401, the purchase and sale agreement, but it was not in a place that you could use the notification, so we've inserted it to match what was in the 401, correct? Okay. And I think that takes care of my portion for now,
For a while.
for a while. We saved the best for the attorneys to dig into.
Am I up next?
It says Todd
Yes.
Scholler is going to be dealing with the RF 707, which is my favorite form.
Is it?
It's the least used.
Do you want to do it then?
No,
Oh.
I just want to give it a little publicity.
Okay, well, let's give it a little publicity. So here we are. We changed the title, trying to give it a little more accurate description. It's not always going to be a special stipulation provision or something. Sometimes you're going to be using these in other forms. So we tried to make it clear that so this verbiage is available to folks to refer to. There are situations where you have unique factual patterns that need to be addressed, and if that is the case, this might be a form you want to look for. Look through the form to see if there's something there that might suit your client's needs. We're really trying to avoid people having to play draftsman and come up with their own verbiage. And I think most brokers would appreciate that out there. So that was the goal when we first did this form. This form has been available for some time, and I don't know exactly how long, Bobby might recall, but it's been here for a while, but it's been largely ignored. It's been sort of the stepchild of the forms world, in the sense we haven't paid a lot of attention to it. So what we tried to do this year was reorganize the form largely, and try to put things in order that we felt, the forms committee felt like would be more popular, more used, provisions towards the front, but also tried to clarify and simplify some of these provisions, because again, they've been out for some time, but they've been sort of just left there to dangle. So with that in mind, we can tackle some of these provisions, and I'll just show you some of the ones that we felt like we needed to add and clarify. So for example, number 1, which is on page 46 of your book, if you have a booklet of forms, we noted that with regard to expenses, this could be inserted in the closing expenses paragraph of the purchase and sales agreement. And so we said seller to pay a percentage of the purchase price or pay so much in terms of dollars towards buyer's expenses and title expenses as identified herein, meaning in the contract itself. And so again, just cutting to the chase, putting the verbiage there that's clean and neat. What was there was rather expansive, and this just seemed to make more sense. The first right of refusal verbiage, paragraph 2.
Can I say something?
Absolutely. Jump in.
We calling it now buyer's expenses, so that we felt you didn't have to say closing costs, discount points, prepaids, all of that, and make sure that you had included everything. And if you didn't put all of that, then that didn't get included. So this buyer expenses became this sort of all-encompassing.
We've kind of defined
and
that.
so now
Yeah.
you don't need to have all that broken out. We felt this really took care of it, if they use this particular language.
Yeah. And I don't know who's covering the 401, Bobby or Ron or whoever, or all of us.
We'll get
I don't
to-
know.
yeah, right.
But yeah, we'll talk about that, how we sort of define those a little better so that we can refer to them, with a defined method. So.
Thanks, Todd.
Paragraph 2, first right of refusal. Again, it may be that there's an offer made and the seller wants to counter the offer with this first right of refusal, right to continue to market, which we'll talk about a little bit later, this form that you are probably used to and are accustomed to seeing. So this would be some verbiage that they could insert in the counter offer, that the buyer and seller agree that they may continue The seller may continue to market the property as outlined in the attached first right of refusal addendum. So it would go along with, for example, the counteroffer going back to the buyer. Okay. And please, you guys jump in if there's anything. This form actually, we sort of parceled this out to some subcommittees, and lots of people worked on this form. So hopefully everybody will appreciate the changes.
It really is, for brokers, a really good education tool.
Mm-hmm.
And I think that's what we're trying to really promote it, that to make this, it's not really a form in the sense of between a buyer and a seller. It's a resource material for agents and brokers so that we can ensure that we're writing something correctly and covering legally what we need to without having to do it ourselves, so to speak. So,
and if you look at the bottom there on 5B, contingent on sale of property, flip to the next page, you'll see basically what we've done is kind of cleaned this up a little bit. Agreements contingent upon the sale of a property located at a certain location on or before the closing date. If the property does not close on or before the closing date, the buyer may terminate this agreement with written notice to seller with refund of earnest trust money to the buyer. And then we deleted some verbiage again, just to clean it up. You know, it's really that simple. We made, again, some minor tweaks to some of these provisions that I don't guess we need to talk about all of these, do we, Bobby?
well,
Or do
I
you
just
want
want to
to?
make sure that everybody understands why, if they have any questions, such on C.
Okay. All right, C. We added a little thing here. This is approval of others. This agreement is contingent upon blank person viewing and approving the above described property, and buyer shall notify seller or broker on or before. So we added or broker, that the property is acceptable or unacceptable. And then it goes on to say if it's unacceptable, the buyer is to provide notice that they're exercising the right to terminate. And at the end of that, it in essence becomes sort of a self-executing provision where it says, you know, if the contingency is not removed by the date that we specify above, then it's deemed waived. So in other words, it goes away if they don't object. There's no need to do something further.
And for an education purpose, that's where a lot of these hand or agent written little special stipulations fall down. We don't have the or what or the consequences, so then it becomes a very vague or less enforceable provision. So we're trying to get agents educated again as to how these must be worded to be enforceable.
I've always maintained that the special stipulations part of the contract is the most dangerous part of the contract. That's where more can be done that might, you know, muck up a transaction or cause some liability issues. We've got some great agents who write really great provisions, but sometimes if you're in a hurry and you're on the fly, that's where mistakes can happen. So.
And these can be found, of course, there's a form that can be copied and pasted, but I understand it's right on the front page of the transaction desk where you can access this and literally copy and paste into the special stipulations or the form that it may need to be on. I know I'm speaking to the choir here, but I wanted to reinforce for all of you out in the world.
D, seller's right to find suitable housing. We just changed the title a little bit, but then we also tweaked the verbiage. The contract's expressly conditioned upon sellers entering into a written contract to purchase or lease a property acceptable to the seller on or before such and such date. In the event the seller does not contract for an acceptable property on or before the date, the seller may terminate the agreement with notification to buyer. Upon termination, buyer is entitled to a refund of earnest money, trust money. Radon didn't change. F, we just clarified the title. It's alternate appraisal language. We have appraisal language, obviously, in the contract that we'll talk about a little bit, I'm sure. But this is some language that could be added to other documents. You know, I guess should we read this? This didn't change, though. I don't know that we need to go through it beyond that. Bobby, stop me if you feel like.
No, we just wanted to call it alternate, so they knew it wasn't the same as the appraisal. We weren't repeating what was in the contract.
In G, bankruptcy pending, there's a little tweak there on line 71. In the event that a final judgment sale authorization is not granted on or before, as opposed to by. Again, just a little bit more precise in the verbiage, trying to tighten that up a little bit. Again, under divorce, paragraph I, we took out the word by and added on or before to tighten that up a little bit. And then changed the last sentence to read, upon termination, earnest money shall be returned in full to the buyer, and the parties agree to execute all applicable documentation. So I guess that's all that needs to be said about that.
Yeah, and the important thing to note is all of these may never be used by some people, and it may be once in a career, but at least there's a resource that's to go for. So before anybody starts writing on their own, check the RF 707 to see if we've already covered, because we tried to add some things that we find come up more often that were not in here, so we did add
Yeah, we did add some things as well. Under J, we retitled, if you look at line 91, we called it a land survey. It's technically it's a boundary survey. That's more of an industry term that would be understood as opposed to a land survey. So again, just sort of the semantics of the situation. Page 3, I didn't note any changes.
Nope, we didn't.
Page 4 it gets interesting because we felt like there was, and I don't remember who proposed this, if it was a member or somebody.
There was a member that really felt that this pool situation's coming up more and more often.
Mm-hmm.
I guess more people are putting in pools in Tennessee, so
there you are.
there we did this.
So we came up with this verbiage, and the bulk of this is new. So the committee worked very hard on this. We'll just kind of read through it under pools, starting on line 159. This agreement is contingent upon seller providing the following additional information about the existing pool within blank days after the buying agreement date, and the buyer's review and acceptance of information concerning. And then we list 6 different things: the type of surface, filtration system, age, the age of the liner, which is quite important, age of the pump and heater, if applicable, age of any additional features, hot tubs, waterfalls, etc., etc. In consideration, the buyer having conducted reviews of the above matters, the sufficiency of the consideration being acknowledged, buyer's sole discretion may elect to terminate the purchase and sales agreement on or before the expiration of the above referenced inspection period by written notice to the seller if the above matters are not acceptable to the buyer, and the buyer shall be entitled to refund of all earnest money. In the event the buyer exercises the right to terminate under this contingency, buyer shall, at seller's request, furnish documentation supporting the right to terminate.
Mm-hmm.
So I don't know if you want to comment on this further, but basically there's a time period that you can designate that may be different than the inspection time frame. They sort of carved this out as a special thing.
Well, and part of the reason was the agent several agents that requested it wanted it to be placed in the property condition disclosure. And again, we couldn't do that because the law doesn't require the seller to do that. But if there is a pool, obviously a buyer's going to want some of this information. So education, again, this is the place where you can copy and paste and insert this in special stipulations if a buyer is dealing with an offer that has a pool.
If I might insert another comment to this, back to the property condition, there was some pushback last year from a lot of agents that some of the information that was in the property condition report had been removed, that it was helped in the marketing of the property to know the age of a roof or the age of the heating and air conditioning. Yet those, due to the severity of the repercussions that the legislature has imposed upon a misstatement of fact in the property condition report, it's a little strong. But just like you see here on how we've done this in the special language with pools, you could just as well work the same way if you feel like you have a buyer that's wanting to know age of equipment in the house, HVAC. It's a good way of using that formatting to, you know, for a certain period of days to due diligence, disclose to us if you know it, if you know the age of the HVAC system. You can tie this in using similar language the way we've done the pool, but maybe for HVAC.
That's a good point, very good point. Yeah, so it really puts the burden on the representative of the buyer to make sure that they've inserted clauses to protect the buyer and cover whatever it is they're interested in knowing. Any questions?
Any
We
questions?
have a question on YouTube, actually, and it says, the pool contingency isn't clear on how long the buyer has to do their review, or am I missing that?
Second round.
Let's see.
Second round.
Yeah.
About days.
Yeah, it ties together, I think, if you read it in its entirety. You've got so many days to review and accept the information. And then if you dip further down, lines 169, well, really 168, the buyer at buyer's sole discretion may elect to terminate the purchase and sale on or before the expiration of the above referenced inspection period. So I read that to mean, you know, you're going to have to review the information and choose to terminate or not within that specified period. So
Keeping in mind, this is additional language within the purchase and sale agreement, and so when it says the above reference inspection period, that would relate back to Section 8 of the purchase and sale agreement, the time frame designated for inspections in the agreement.
Oh, okay. So I don't know if that answered their question or not, but I'm sure we'll hear back if it didn't. So, okay, just pushing through a little bit, and again, I guess if people are talking about these and looking at them and critiquing them and whatever, that's good, because that means they're paying attention. So
I like it.
yeah,
I like it, and I like that. So can we say how they can check in with us with questions?
Sure, yeah, I'm watching the YouTube feed, and I'll continue doing that while we're on here. Otherwise, we've got people in here, and then the people at the locals can also ask questions.
Oh, is that where that is? Who's,
Yes.
what local is that? We wanted to say a shout out.
I think we've got Upper Cumberland, and there's one other one. I'm not sure exactly who we're looking at here.
Well, thank you for being here, Upper Cumberland and whoever.
Yeah, I can find
hey,
out.
you got away. Paragraph 7, the HOA review period. Seller agrees to provide buyer with the requested condominium information as outlined in the attached request for information document, which I don't have that number. I don't know if somebody has that number. We
It's
have
the 709.
709. Look at Miss Bobby.
My other favorite form.
There you go, your other favorite form.
I like those
Okay.
sevens.
So we're going to provide that information no later than blank days from the buying agreement date, not to exceed 10 days. Purchase is contingent upon the buyer's acceptance of all information provided. Buyer shall remove the contingency or terminate within so many days after receiving the information. So that's the way that would fly. So we have the form that's available to request the information, but this allows you to specify a time and tie it into your offer, if
Is
you
there any
will.
way that we can, and I get it, you can alter these, you know,
Yeah.
but can we take out and make it a little bit more general versus condominium specific? Because I think we use this all the time with any HOA.
Mhm.
So this is a great, I love the language in this, but I think we could take out the condo specific.
Did we, where did we?
Well,
go?
she just figured, yeah, we referenced the condominium information.
Right, we have.
So
We are referring, this is for all.
That's requesting the condominium information.
Oh,
Is there
did
any
we
way-
not
Yeah,
change that?
no.
We didn't change
In
it.
there in the second.
I mean, again, I see no reason you couldn't, you know, just modify the word to
Sure.
say, you know, this is verbiage. And again, we have to be careful. We walk the line. We don't want you to, you know, draft language as a realtor
Sure.
necessarily. But at the same time, sometimes slight modifications have to be, you know, just obviously do that with consultation of your broker, obviously, and do so carefully. But I mean, sometimes if you could slightly modify this to request information related to an HOA other than a condo, sure.
And that's a really good idea.
And I'd
because-
rather do that than just make it up, you know.
No, I think
Talk
this is
about
great
that
language.
next
And that
year.
may be something next year that they
That's a
can.
good point.
Mhm, very good
Mhm.
point,
Yeah.
of changing the title.
Yeah.
Todd, can you just clarify, just for education purposes, why it says not to exceed 10 days?
Let's see.
It's
Number
because,
7, line 83.
I'll be honest with you, I don't know. I thought we just picked that day.
we didn't, if you look at the 709,
See, you're picking on the 709, so you know, I didn't
Well-
study the 709.
the reason we did is in the 709, it does state that,
There is
I
a
don't-
statutory
there's a
period.
statutory that says it has to be
Yeah,
delivered within 10 days.
that's right.
And so we wanted to allow someone to ask for it sooner,
Right,
but they can never go longer, because then they would be violating the statute.
that's right.
I'm
There is
sorry.
there is a statutory right. See, I live in Gallatin, so we don't deal with that form. So
Wait.
we just
Just
wait, right?
wait.
I know, you're on your way up there, right?
Yeah.
Okay, paragraph 8, rental leases and review. This is, you know, more and more we're seeing, you know, agents having, you know, people are looking to buy properties that are currently used as a rental and having to deal with existing tenants and deal with review of leases. This verbiage will hopefully help them do that more effectively. This agreement is contingent upon the buyer's receipt, review, and inspection and satisfactory approval of all existing leases, security deposits, and rental applications. Seller shall have blank days from the buying agreement date to provide the information. Following receipt, buyer will have blank days to review all submitted information. After such review, if after such review the buyer is not satisfied for any reason, then the buyer will notify the seller in writing, and the buyer may terminate this agreement. All earnest money shall be refunded to the buyer upon timely termination. If buyer does not notify the seller within the time frame, the contingency is deemed waived. So again, we're hoping to get them, you know, to get that information. Oh, thank you. All right. There we go. Guess I'm not loud enough. Okay. So that's what that is for. Hopefully that's kind of self-explanatory. Paragraph 9, inspection period if property is used as rental.
This was necessary, we found, due to issues that kept coming up.
Yeah, having a hard time getting in to see properties where there's a tenant. Within the agreed upon inspection period, the buyer shall contact the seller to set up a mutually agreeable time for the buyer to have an inspection of the property. The buyer must provide the seller with 5 days notice before the end of the inspection period, and seller must make the property available for inspection on one of those days, within that period. If a mutually agreeable time cannot be reached within the time frame, the contract may be amended to extend the inspection period. If the seller is unable to provide a day for inspection to be conducted, buyer may terminate the contract, giving them a clear out. If terminated, the buyer is entitled to a refund of the earnest money. In the event the buyer does not provide sufficient notice to the seller, the buyer shall have forfeited the right to terminate under this paragraph and shall not be entitled to a refund of earnest money. Again, it gives you something to work from. Every situation is going to be different, and you know there's going to have to be you know, some flexibility, but depending upon how difficult the tenant is and how evasive they are, you know, trying to allow for that in some fashion for agents who are struggling to deal with that. That's what the committee was trying to do here. So, did you want to comment more on that, or?
No, I thought that was very good.
Let's see. If you'll drop down to paragraph 12, non-refundable earnest money. In the event the buyer elects to terminate the agreement as allowed herein is not otherwise in default, the earnest trust money shall be deemed non-refundable and shall be paid to the seller as additional consideration for having entered into this agreement. In the event either party is in default under this agreement, the provisions of Section 13, which have the default language in there as a breach of contract language, as provided in this agreement shall control. So it basically it sets up a situation where, look, if the buyer, the cost of admission, I guess is the way to say this, the cost of admission here is the earnest money. So in essence, you're going to put up your earnest money and you're going to do all your due diligence, and if you want to get out of the contract, that's fine, but you're going to leave that earnest money.
And this would happen in the case of, let's say they wanted an extension and they had extensions, and so the seller's saying, okay, you can have an extension, but now your earnest money is non-refundable, or, you know, so it wouldn't necessarily be in the original contract, the 401, it would probably be in an amendment or an addendum or a closing extension, or it's a condition of something that's being asked, probably usually above and after the initial offer. Not that, I think builders are using that quite a bit. Okay.
Yep.
Well, with our given market, there's cost to the seller and risk to the seller the moment the property goes off the market. And this could be used in a situation where it's just the seller's being compensated for having allowed the house to be off the market while inspections were taking place. It has nothing to do with default. You know, default's a different issue. But just, I'm canceling the contract because the inspection was not satisfactory to me. Well, then the sellers had the house off the market 2 weeks. So it would be an opportunity there if you have a situation where, you know, the seller says, you know, I want to be compensated for that. This paragraph would work great.
I feel like the contract is so slanted toward the buyer. I appreciate this language.
Well,
because they can look for anything.
we try to, we work really hard to be neutral. We do, and I realize sometimes, you know, people view it as slander one way or the other, but we really try hard to make it as neutral as we can. But this kind of verbiage that you could pull from, you know, depending upon your market at the given time you're writing the offer, look, sometimes you know, you want to go in and be as amiable and open as...
In a multiple offer
Yeah.
situation like we're having a lot in Nashville, those multiple offers, this becomes even a popular one for buyers to insert in to make their offer look more pleasing.
Yeah.
You know, it is, well, that's what I have to say about it. You had something.
You wanted to talk about earnest money, didn't you?
No, I'm not going to go there. But you know, the offer, the 401 is initiated by the buyer and the buyer's agent. So obviously, a buyer is going to initiate the 401 in their favor. It's our job as brokers to educate our sellers' agents of how to do counteroffers properly and how to insert. So some of this is in counteroffer, not necessarily in the special stipulations section of the 401. So sellers really need to know what they've got to work with. Thank you for bringing that up.
Yes, sir.
So just to clarify, I'm listening, and you make a perfect example as far as home inspection being done, and yeah, we want to get out of it anyway. There is that loophole because it was not satisfactory to us. You can walk away. You're saying with this verbiage, the seller can say, okay, if you want to walk away, per the contract, it does say you can do that. However, because time off the market and things of that nature, we want to hold that earnest money. The listing agent, seller's agent, has every right to use his verbiage to ensure that they get that earnest
In a
money.
counteroffer. It would have to be done prior to the binding agreement.
And depending, I guess, depending upon how large the earnest money offered, it could be a portion of that rather than all of it.
Sure. Yeah,
And that-
absolutely.
You can also do it in an amendment if you're extending.
Right.
That's when I do
Okay.
it.
Okay.
And that's where this may
Extensions is
be.
where this comes up. The sellers have a lot of leverage when they're asked to extend a closing date or an inspection date, and they are free to do so, but they can up the ante a little bit and protect themselves with this kind of clause.
Okay. Any other questions on that? If not, we'll move on. Paragraph 13, inspection costs. In this, well, every situation is unique, but this deals with, and I don't remember if there was a member that brought this up or how this came up, but sometimes you just have one of those properties where it's difficult to inspect because of the situation you find, you know, personal property or whatever. So this sort of attacks that situation. This is section A there on line 225. In addition to seller's obligation under this agreement to have all utilities, services, and other items operational during the inspections, seller will also ensure that the crawl space, garage, and/or attic areas will be accessible and free of debris and/or personal articles.
Yeah, because we found a lot of our members have been complaining that they'll spend the money, they'll get the inspector out there, and then he'll give a report, but he couldn't inspect so many things that therefore, in order to get a proper inspection, they'd have to pay again to have them go out. So that's where we put B, if that should happen. If they don't have that, then B states, go ahead, Tom.
If anything is unable to be tested or inspected during any of the inspections because seller did not have utility services and other items operational, and as a result, buyer's inspections that were paid for by the buyer are unable to be performed, the seller agrees to ensure the utility services and other items will be operational during any follow-up inspections, and seller will pay for any and all fees incurred by the buyer in order to have the non-functioning items re-inspected. And I suppose you could also deal with if there's, again, this is a kind of a fluid situation, but if you couldn't do your inspection because either something wasn't operational, you could insert too, there was, you know, that it was inaccessible, you know, due to personal property. So again, you may, this gives you a very, very good starting place, but you may have to talk to your client and address their unique situation there.
We just wanted to give the seller again, I'm sorry, the buyer the right to collect that reinspection fee for no fault of their own that they sent an inspector out, because sometimes they charge quite a bit to go back out there.
Yep.
So the one thing I don't see here is, you know, when is that fee supposed to be paid? Is that time of? Is that at closing?
Well, the way I would read it is it would have to be collected. So I guess you would basically make a demand and contractually.
You could probably do it through closing of the title.
Yeah, that's a good question. I guess.
Well, the
it could
problem
be
is,
paid at the time. It could be paid at closing. And then if he
If
doesn't
it doesn't
close, you'd be in a
close,
position
yeah.
of. I mean, look, some of this is you've got teeth there, but you'd have to actually care enough to pursue it. Frankly, you know, is it a large enough expense that if the deal
it
falls
is a
apart,
condition of the contract.
Yeah.
But,
Right.
yeah.
You're right, though. It's left a little bit
That's
open-ended.
why we have our vice chair here. She's making little notes because
We'll talk about that next
it's
year.
so interesting. We always think there's nothing like, oh, we've done so much work. And then we sit here and think, oh. And so this is how we hone it and clarify it. So she's making little notes of these things. I don't think they're urgent enough to make a today change for next year. Unless we come across something that is really a huge angst. But I do think these are things that the committee next year needs to review.
What's funny is you've got so many eyes looking at these forms,
Ugh.
and everybody on the committee works really hard to study them, and you can still, despite everybody.
We were so proud of this.
Yeah, that's right. But yeah, again, these provisions are insertable, and if it requires a slight tweak, you know, for your situation, obviously, again, talk to your broker, but, you know, that's probably not something that you would have an issue with doing. Yeah.
Yeah, you could, I mean, I would just add at time of inspection, pay to, you know, seller pay to vendor.
Yeah.
I mean,
That
that
would
way
be
you're
the
just
easiest
paying
thing,
the
honestly.
vendor a check
Yeah.
and it's done.
No matter if it closes or not,
Not,
it's paid.
that the vendor gets paid.
And what we found with this specifically entered, it does alert a seller, uh-oh, I better be a little more cautious because
Yeah.
I don't want to incur it. So it tends to maybe help eliminate some of the problems before we get there.
Hopefully.
Yeah.
You never want to be in a position of having to actually enforce, some of these things. I mean, you put them in there hopefully to raise awareness and as Bobby said, proactively avoid them, by addressing it. Access to a public road. We had section A there, that the seller warrants the subject property has right of ingress egress. Section B, we added, if the access is shared, the buyer's obligation to purchase is contingent on the receipt and approval of a shared driveway maintenance agreement. Seller agrees to provide buyer with a copy of said maintenance agreement within so many days of the buying agreement date. If it is unacceptable, buyer shall have blank days following receipt of the maintenance agreement to terminate the purchase agreement. Otherwise, the buyer is deemed to have accepted the same. So, in our area and other, outside of Nashville, you still see a lot of shared driveways. You see lots of easements and access questions. So, again, this gives them something to talk about because, look, maintenance agreements are important practically, but functionally they're important because certain loans require them to be in place in order to provide that loan. So, again, hopefully something that they can use there. Paragraph 15, the buyer/agent buying to sell for a profit. So this used to be titled agent is principal and or relative of principal. And we struck that part out, I presume, Bobby, because it's in another form. We have a personal interest form, as I recall.
And it really wasn't stating really what it was for.
Yeah.
It didn't make any sense. So
It didn't
we
make
shortened
sense.
it up to something very clear.
Yeah, so if you look at the next line, it basically says all parties acknowledge the buyer/agent intends to sell the property at a future date for a profit. Fairly straightforward.
Hopefully.
Hopefully, yeah, hopefully.
This was sell the property. We're not dealing with assignments.
Yeah, well, to sell the property is yeah, it doesn't seem to address an assignment. So, we can talk about assignments if you want to, but
No,
yeah.
that's not.
But shouldn't the assignment be a separate issue?
Mhm.
Yes, it is.
Mhm. Yeah. And there actually is an assignment provision. If you look at 19, non-assignability, which that's old, that's been there. But purchase and sales agreement shall not be assignable by the buyer without prior written consent of seller. So.
And that's because all contracts are assignable in Tennessee and does not need to be disclosed to the seller that you're assigning it,
Yep.
even for a profit.
Yep.
No, that provision is already in the purchase and sale agreement. Correct?
Yeah.
It's just that people seem to have a hard time accepting that. So if you do not want a property assigned, this would be the verbiage that you would have to put on number 19 in a counter.
Yep. Okay, well, those are the additions that we made, and hopefully some of those will be beneficial.
And I just, for reference, the rest in red is what we, the committee, voted to delete.
Yep.
And there was a lot, we met 7 times this year for a minimum of 5 hours each. And people came, we met in person, and they came from all over the state. And so a lot of work went into this, and we eliminated them because either they're in another form or we have a
YouTube
question.
Yes, and it's off of YouTube, and it's a 2-parter. So the first part is exemption. Is a builder that has knowledge of a latent defect actually exempt from disclosing that known defect? If not, are we misleading them into thinking that they are because they signed a form?
Okay, I need clarification in that a builder is exempt, and so they do not have to disclose or fill out anything but those 6 items that are on that new disclosure, additional disclosures. That's all they're required.
Okay.
Unless the builder is a licensed agent. And then a licensed agent is never exempt from anything that they have actual notice or knowledge of.
Before you ask the answer, the second, let me clarify something. Where the question's probably evolving from is from common law before the property condition was enacted by the legislature. Sellers had a duty to disclose patent defects. Latent defects. The example would be if you walked into the room and you could see the ceiling caving in, that was obvious. You did not really have to disclose that. But if you knew the sewer lines were backed up, there were hidden defects, a seller had to disclose that. And that's common law, and that is still the law. What you will get when you get a half dozen attorneys having this very discussion is differing opinions as to whether when the legislature enacted the property condition requirement and allowed certain people to be exempt, did that also exempt them from the common law? My position is it did not. But you will get lawyers periodically that will say, oh yes, they're exempt from the common law because the legislature specifically dealt with it. I'm not personally familiar with any cases that have addressed this, but I err on the side of safety. When you know you have a hidden defect and someone cannot see it, to hide behind the, oh, I'm exempt, is probably a dangerous step.
Mm-hmm. Definitely.
Because folks will find out sooner or later.
Well, and you know, obviously, typically, there's an implied warranty if there's not an express warranty, you know, with new construction as a builder. So, you know, they're still going to probably be on the hook if there's a problem that falls within the warranty. So, I don't know, of course, we'll talk about warranties a little bit later. But
and by the way, just for purposes of YouTube, these are Tennessee questions we're answering. If someone's out in another state, they need to be checking with their local state officials for that.
Right.
Disclaimer here.
And the second part of her question, it says, in regard to the binding agreement and other notifications received, does that not go back to agency/representation status as to if they have the standing to receive the notice? Does that even make sense?
Well, if I'm understanding, y'all chime in, but I mean, in the contract itself, we sort of carve out certain situations where the agent is entitled or authorized to receive notice. Contractually, we do that. We also, at the same time, limit in the 401 the extent that they have the authority to receive notice and so forth. So there is common law agency, you know, out there, but we've confined it within our document, hopefully, to give them the authority they need, but no more. Would you agree with that? Or?
Yeah, and I don't think agency representation agreements would go as far as to say that a principal will say a seller is authorizing the agent to act on their behalf as an agent. I mean, that's what the Brokers Act is all about, to change that. But when in a very limited area in the purchase and sale agreement, because of our electronic world we're living in, we have put a very narrow exception where an agent can receive notice only notice as to terms in the contract. If an agent doesn't want that responsibility, then they need to be looking at that clause in the contract, in the purchase and sale agreement.
Whoever sent that question in, if we missed the initial point, please resubmit.
Okay.
That's mine.
I think that's pretty much all, other than what we took out, which is there in the book for you. So
the next thing we're going to do is the purchase and sale agreement, the RF 401. We want to take a break. Let's. It is here in Middle Tennessee. It's about 10:16 or 17. Let's take 10 minutes, and we'll be back and continue on. Thank you. Okay. Okay, welcome back. Hope you had a good break. I wanted to make an announcement to those of you who are viewing us, and we are viewing you, which I believe is Upper Cumberland and what's the other one?
I think it's Central West.
Central West. Hey, what we're saying is we have been notified that you can now wave your hand and we can see you, and then we can unmute you and you can ask questions and we can hear you. In fact, we were listening to everything you said while you were on break, and that was quite interesting. So, we have recorded everything that you've said and have turned it over to the authorities. So
Full disclosure.
the Tennessee Real Estate Commission is listening as well. No. Okay, so raise your hands, wave at us, because we can see you, and then we can unmute you, and you can ask a question directly. Hopefully that won't be too hard on all of us. Okay, we are now going to tackle the changes made to the RF 401, which is the purchase and sale agreement. And the good news is I don't think we made as many changes as scary. So on page 1, which is in the booklet that we have been provided on page 53, there's no changes. Yay, turn the page. And then on page 54, there's no changes. So, moving right along. Then we get to page 3 or page 55, page 3 of the purchase and sale agreement, page 55 in the booklet. And here's where we spent, you know, for such a little blue and a little red, this was at least 4 hours worth of work. And it looks so simple here as we've done, but we have tried to clarify what it means by closing costs, discount points. All of this was getting so confusing, especially when you got to closing, as to what was considered a closing cost, what was considered prepaids and all that. So we changed it all to closing expenses to totally encompass all of the expenses that either party would have. And those were listed, and they stayed the same. So I think we like that. I like it a lot.
Well, if I might add on something here, is it causes a little confusion in the industry when you hear seller's expenses, buyer's expenses, then title expenses. And some people say, why? It goes back to the core of the development of these agreements across the state of Tennessee. You deal with real estate on customary closing expenses. In so many areas across the state, the expenses you see here for sellers are customary. They've been that way for years. The buyers, same thing. The problem we've had through the years is that title expenses are not customary. They vary greatly across the state, and when you look at the cost of title insurance, that's a large dollar amount. So you just couldn't say, well, let's do it the way one section did and not the other. So it's still an expense. It's just that title expenses are in our efforts of keeping a balanced contract agreement between buyers and sellers on certain things that have large impacts. We leave the door open for the parties to be able to negotiate. So we're trying, as Bobby says there, we're trying to clarify that there's the seller expenses, buyer expenses, and title expenses. And then we go on to say at the line 147 that these are not the same for all people all the time. And so we leave the door open for them to be negotiated in any manner. Mm-hmm. With one provision. You have to be careful in your communities with FHA and VA lending, because they still have what's considered normal and customary expenses for a given area. And what may be normal and customary in Memphis is not normal and customary in Chattanooga sometimes. So you can't just put all the cost over on the seller side, because I think you could get some pushback from the lender.
Some non-allowables. Yeah. It's gone down, though, significantly. It's only a few $100s, so it hasn't been. But Ron is correct. And so to properly use this contract as a buyer's agent, that line 145 is where you're going to put who is to pay title. So you could put seller to pay, buyer to pay all, seller to pay all. And then you go to line 147, and this is where you're going to modify it. And when the line, in the RF 707, we told you you could put seller or buyer, seller to pay, buyer to pay, whatever costs. And you can fill that in as applicable. Just make sure it's very clear that that includes or doesn't include the title. In other words, you may be wanting it to be, say, $5,000 in addition to what the title was, not including. So again, we're just making sure that this is the place to make that. Is it wrong to put it in special stipulations? No, but this is where you're dealing with it. We created this, and since we created this, we'd like you to use it where it is related, right? Okay. And then under closing, nothing else changed except down on the very bottom of page 3, page 55 in the booklet, line 158. It says, in the event, earnest money, trust money, if applicable. We are finding, believe it or not, that sometimes trust money or earnest money is not required or asked for or delivered, and that does not make the contract null or void, right? You don't have to have earnest money as consideration.
Correct. Right.
I know this may shock some of you, but that is, so applicable has been put in there, and you were happy about that.
Very happy.
He continues to be happy.
I don't like the earnest money.
Yeah, well, believe it or not, we almost had a consensus to eliminate earnest money completely, but that was pushing it way past anyone's ability to function.
Rebellion.
Okay, nothing happened on page 4 or 56. Going to page 57, which is page 5 of the purchase and sale agreement, we have eliminated 237 to 240. And why did we do that, Ron?
There to 261.
And we eliminated, we moved.
Yeah, moved it.
Let me skip the 6 and go down to inspections. Look at line 261. We felt that that particular paragraph, even though it was in bold, was not in a place that really called attention to the seriousness of failing to have the inspection. So we moved that particular 261, that little red line, and we moved it over to page 6 or page 58 in the booklet onto 286 or 287, right in there where we added the blue. Do you see it? Okay. The reason we put it in here is this is where we're dealing with the actual time period. And we felt that this would be the place to alert buyers that if they do not conduct their inspections in that time frame, they are going to accept the property as is. So all we did was move it to what we thought was a more prominent place to make sure that buyers really understood that. Okay?
Bobby, on paragraph 6.
Thank you.
As I recall, and we removed that because I think for a couple of reasons. One, the property condition disclosure statutorily is supposed to be provided prior to the contract, prior to acceptance of the contract. The other thing was that it was prompting some agents to include it as part of the contract. They would attach it or make it an addendum to their offer or what have you.
I'd like you to speak to that because that came up again. Why is that so significant? Many agents are putting in the exhibits and addendum, the confirmation of agency, the property condition disclosure, the lead-based paint. Why is that not a good idea, Tom?
As I understand it, there was quite a bit of concern raised back a few years ago by the E&O carrier, some of their lawyers, about including that property condition disclosure statement as an addendum to the contract might in fact extend the liability of agents for those representations for the contractual period of liability, which is, Ron, 6 years, is that right? As opposed to a 1-year limitation of liability under the Property Condition Disclosure Act itself. So they said, look, let's be very careful that you don't want to make that a part of your contract. It's a completely separate issue. It's a disclosure requirement. It's not a matter of the contract. You don't want those representations being included in that document. And that was the primary concern, as I recall.
Right, and I've had some agents say that, well, isn't it to the buyer's best interest to have that 6 years in there?
Well,
and I
guess
know,
it depends on
and
which
this is
side
the
of the fence
kind of-
you're on.
Right,
Yeah.
okay.
But, you know, we typically have been teaching, I think, you know, it's best to keep it separate. It is a disclosure. It's got its own statutory period of liability for, you know, misrepresentations. So that's the way it's been pushed.
I appreciate it, because that has come up quite a bit, so.
So, may I ask then, you were saying this for the property disclosures, what about in fact on the confirmation of agency and those other items that people do list in their exhibits and addendums?
It
I'm
really
talking
doesn't
about
have
training my new agents.
Yeah.
Like, don't worry, you know.
I mean, those are separate documents. They're separate agreements. The contract should only contain things that pertain to the buyer and the seller, and agreements between the buyer and the seller. And all of these other agency forms have no place. In fact, for years, we've worked very hard to make sure that, you know, we keep all of those agreements separate. Your compensation is separate in its own documentation. It has nothing to do with the deal between the buyer, this buyer and this seller. So if it doesn't have to do with this buyer and this seller specifically in their agreements, keep it out. There's no reason to incorporate it.
And we're teaching that in the core courses, so when your agents do come to the core course, that's what they're gonna hear. So you may want
Because
to.
you do see them come across both ways. And, you know, you'll have contracts come in where some agent sits there and writes them all in, and other ones come through totally not, and.
Well, keep in mind that addendums control of what's in the language of the purchase and sale agreement. So every time you attach an addendum, you open the door for a possible ambiguity or contradiction in some way that's going to lead to a dispute. That's a document the seller may have, you know, filled out 6-8 weeks ago earlier, and in the back and forth quickly it's being attached, and people aren't paying attention, and you've got some conflict with what your real agreement is. So it just adds to the confusion. I just don't think it's a good practice to add any addendum that is not permanent.
And certainly never the MLS number.
Yeah, well, that'd be like adding the MLS information to it.
Do not
as an
put
addendum.
that in the contract.
You know, it
As
says-
everything per MLS, correct? That's a big
We've
no-no.
had a couple of situations where somebody tried to incorporate what was in the MLS, and what was in the MLS, unbeknownst to them, had changed, because that can be modified unilaterally by the seller. And there was some dispute as to what was included. A lot of times it deals with, you know, some personal property or something that's mentioned or something in the MLS. And you know, I know that Bobby teaches, and Ron and everybody else teaches, you know, look, if you're going to incorporate something, if you intend to incorporate something that was mentioned in the MLS, do it specifically by reference in the appropriate part of the contract. So if it's personal property, there's a whole section devoted to, you know, personal property that shall remain, or not. So.
And at the bottom of the MLS, it says this information is deemed reliable but not guaranteed. So it's just not something that you want to incorporate as an exhibit.
I agree.
Okay.
So nowhere in the purchase and sale agreement should there be any reference to per the MLS?
On actually paragraph 6, we made paragraph 6 the lead-based paint disclosure, but we did eliminate see attached lead-based paint disclosure for the same reason. So that's what we did there. And back to page 58 or page 6 of the purchase and sale agreement, I hope you all are in agreement that that was a better place to have that caveat about in the event. And then going down, we eliminated, well, we didn't. We had to change section 7 and move the paragraph, so we just cleaned that up. And then in final inspection, this little "and" caused everyone quite a lot of grief. So we decided after hours of deliberation to cross it out. And in that case, it was very specific as to when you can have these final inspections, because the way it was before, you could go at all different times, correct? Isn't that the thought?
The and/or sort of gave you, if you read it.
2 times.
Yeah.
You could go twice.
Mm-hmm.
Now, the thing that comes up here, and I'm trying to sort of anticipate some questions, is on your repair replacement proposals and amendments, they have timeframes in there that the seller must have the repairs done prior to closing. And it's my understanding that you have the right to make that check separate from this, so you can go then. That doesn't eliminate your ability to make sure that the repairs are done prior.
That's good.
Okay. All right. And that is it on the purchase and sale agreement, except for,
Oh, wait,
of
wait, wait,
course.
sorry.
Oh, did I miss something?
Section headings on page 439, line 439.
Oh, I got so excited. I'm sorry. Go ahead. You're right.
Well, basically, this is just kind of some cleanup work that we felt like needed to be done. You know, we didn't want to run the chance of having a section heading actually in some way limit the content of the paragraph. If a court was looking at this, you know, we wanted to make it clear that the sections are just for reference. They're not really to control the scope of the content. So this is more for a situation where, you know, unfortunately somebody's in court and you're trying to interpret this contract. Do you want to add to that? I think.
No, I think you're right on point with that. It's just it's one of those technical boilerplate terms that it takes someone asking the question one day. We had a section heading that left you off guard compared to what the language was actually saying, and so we were just trying to clarify that.
Mm-hmm.
And then
So
finally,
the only
that
other
last,
change was
thing
page
we already
11.
discussed, yeah.
We discussed again the receipt. It was the same correction that we made on the other. Binding agreement received by. Okay.
Yep.
We, as always, try to make sure that the other purchase and sale agreements regarding land and new construction follow very closely, if possible, to the original purchase and sale agreement. So, having said that, on the land, we made a few corrections to bring with the purchase and sale agreement 401 and be more specific to its use. So if you look at, again, page 64, page 1 of the lot land purchase and sale agreement, we made some corrections to bring it to what we have as contingent for the purchase and sale agreement, correct?
Mm-hmm.
So it's just a remodification. We had it still at 2 days and it's really the 3, just like we did.
Yeah.
Did everybody know that in August we sent out which we never do, but it was a mid-year change regarding the appraisal in August? Say yes? Yes. All in favor? Okay, so it did come out, and what we did is we felt that what had been done the previous year was a little strict and a little confining as far as the 2 days, and so we kind of reformatted it with some options, and we also extended it to 3 days. So that came out in August. So that change was made mid-year, and I hope everyone understood that. So we're just bringing this up to the same standard. And on page 2, or page 65, again, this is just cleanup, but we followed the same options 1 and 2 that we put in the mid-year change. Is that everybody with me? What happened is we didn't change all of them mid-year, so now we have. Again, on that, we changed the closing costs to closing expenses. We followed this absolutely the way we did the 401. I do not believe we changed anything until you get to page 8. which was on page 71 of the booklet. And let's see, 409, we eliminated property delivery condition because we didn't feel that land should be, I guess it could be, but clean and free of debris at time of possession. And section headings, we put that in as we did on the other. And we eliminated what we thought was probably inapplicable. Eliminated that under other. And then on page 9 or page 72, we did the same under the binding agreement date, the received by. Any other things on that, ma'am?
No, and I guess I would point out what a remarkable job Bobby has done in terms of dealing with the last two forms, because actually the attorney with Fair and Bates, the TAR's attorney, Anderson, was actually going to cover those forms, and she unfortunately was ill this morning. So Bobby had to step in and
pretend I knew what I was doing.
Well, yeah. So just kudos to her for handling that. So
then we decided to tackle something that we really hadn't paid a lot of attention to, and so we worked really hard this year on the new construction purchase and sale agreement, and I'm going to let Ron Poe delve into that one. That was this was quite a feat.
Well, thank you, Bobby. The new construction purchase and sale agreement has not been something real prevalent during the downturn in the economy, but now that we're seeing an upsurge again, it's more and more people are using it. So we tried to pay some attention to it this year. There was a limitation of time. We couldn't go as deep as we wanted to, so what we did, we began attacking some of the major issues and to fine-tune it. First, you have to keep in mind when you're talking about new construction agreements that you have different stages of new construction. You may have a property that's 80% complete and you're coming in to finish it up. You're not quite to the stage of using a regular purchase and sale agreement, or it could be right from the ground. As we know, many builders across the state sort of like to use their own form. Their reason for using is they have multiple houses going at any given time. They need to be consistent so they know what their time frames and obligations are, which is a valid point. In using this, though, what we did, if you just start with page 1, which is in the book on the, let me get to the book myself.
74.
Yeah, the page 74 in the book. Basically what you have here is that if you're starting with a blank canvas and you're saying for the builder's going to build something, you need to add some information, and we don't have it in the agreement because we don't know what to add. But you need to add what the improvements will be. What are the plans and specifications? What allowances will be listed? Now, we had a couple of forms already that were usable, which was, if you look down at lines 18 and 19, it talked about the pre-construction specification and the new construction allowance addendum. These are forms we already have, and they're usable and they're very good and in-depth if you're working with one. It's important to add some type of plans and specifications itself. I mean, is this you got to have some vision of what the builder's going to build. And if you don't have the plans and specifications, sometimes you can say, be definitive in a similar model presently located at such address. But that's a form. Also, we've added an other in at line 20. That you have to paint the canvas of what the builder's going to build. You just can't say, well, build this house, and then later on, if there's a dispute, not have any direction. So it's much like if depending on where your field of expertise is, if you're new or have not had a lot of experience with dealing with new home construction, and that's a great time to look to people in your office or your broker or sources that people that have, because there's a lot of intricacies that go along that if you're new at it and you just say, well, I've got a form here, that you have to work with the mechanics of it. We also are seeing more and more now where sometimes you'll have the seller may own the land, may have acquired the construction loan, but they've gone out and retained the services of a licensed contractor to actually build. So we're trying to clean up the language. It's the seller you're entering into the obligation, to build the house. But also we think it's important for the consumer to know who the builder is, whose license is being used, who's qualified to actually be the builder.
And those are line 22 through 24.
Yeah. Moving on, we've already talked in the previous agreements and the mid-year change last year about the agreement with dealing with the contingency on the appraisal, so I won't take up the time on that, but we just made that conform with what was done mid-year. If you move into line 57, and you see once again what we've already talked about in the purchase sale agreement and changing closing expenses, trying to identify those. And so that's just a repeat of what we've already discussed this morning. Moving over to, let's see, actually on the section, which would be page 4 of the agreement itself. That would be on page 77 of our booklet that we have here that we've sent out. There's basically, we're dealing once again with this concept of if earnest money is there, we put it applicable in. It's amazing the number of agents, I'm not quite sure which course they take, but so many people believe that if you do not have earnest money, you cannot have a contract, and that's just not factual. So we're just putting a little nudge in there to say, hey, if it's applicable, we recognize everybody typically does earnest money. Now, when you start dealing with the sellers that are builders, sometimes there's situations where the builder may want to retain the earnest money, so you have someone other than the broker or the holder of the earnest money. Moving into line 204, dealing with warranties transfer, we just deleted this little part. It says at the option of buyer and at buyer's cost. If there's a manufacturer's warranty, it passes to the buyer. The buyer shouldn't have to ask for it, and there should not be a fee for them to pay to transfer a warranty. So just clarification, getting that cleaned up. If you drop you see the old item 7, we've deleted plan specifications, and we said we used to have are or are not attached to the signed agreement. That goes back to their very section, page 1, where once again we're putting more emphasis on these boxes. If you don't check a box, then it's not part of it. So if you have plans and specifications on page 1 at line 17, you be sure to check that box. If you don't have plans and specifications, please let me know how you're coming up with the idea of what the builder is going to build. There must be something to define. Moving on into the next page, back at line 268, which is the old paragraph 11, allowances, same thing. We just moved that back to page 1. Nothing new with that. As a result, it's causing our section numbers to change. If you go over to page 7 of the agreement itself, and that would be down at page 80 of the booklet, then all we've done is take some language that was previously up at lines 317 through 320, and we've moved it down to a lower section. And this is what Bobby discussed earlier when we were going through the purchase and sale agreement. We felt it would be more appropriate to make it clear that if a person or a buyer does not exercise their rights to do their inspections, that they could lose all their rights. And this is really important in the purchase and sale agreement. If you have a 10-day inspection period and you don't do your inspections within the 10th day, for example, on the 9th day, your inspector says, well, I think you need a licensed HVAC person to check the systems. Well, that's not the seller's problem. That's the buyer's problem. There's nothing that automatically gives that buyer the right to have more days. They should have thought of that when they made their offer or when they scheduled their appointments. Yes, ma'am.
Go back to page 6 of the purchase.
Okay, page 6, yes.
We did add something on
I'm
line
sorry.
269 that you love.
Oh, by the local government authorities and zoning.
Because we had eliminated some reasons that we thought could be delays that the builders should not be penalized for.
It is conceivable that in section on page 260, at line 269, page 10, delays, that a builder could be told to stop construction because a technical requirement has not been done with a permit or something that's really
rain garden.
Yeah. Yes. Yeah, something that could stop it. So they were trying to give the builder some a little latitude there of extended time. In other words, they're not responsible if the government's telling them you have to stop work for some reason.
So that just gave a little more leeway for the builder to have, because those do happen.
And let's see, moving on then, I was about to say there we covered in the event the buyer fails to timely make their inspections and respond in the time frame, we thought it needed to be somewhere right there that would get the buyer's attention and everyone's attention that you need to schedule these inspections in a timely manner. You just can't wait till the last possible moment because you could very well lose out in your rights. Moving to section 17, this is once again it
Page
says
81.
Buyers, page 81, thank you. Buyers' additional contingencies. As additional contingencies to buyer's obligations to finalize the purchase of the property at closing, the following shall first occur. Now, shall first occur has been added in. Keep in mind, in the purchase and sale agreement, we kind of address a few of these items by additional due diligence, and if the buyer is particularly interested in them, they should consider it. Where on the new construction, we felt this is some pretty critical things, like when the builder's constructing the house, we felt it's critical for the buyer to know that there's no violation of setbacks and encroachments of the property line and so forth. So, but you're seeing it's still boxes. You have to check the box if you want those particular provisions to apply. For example, the very first one, buyer's review of an as-built land survey. Buyer's review and acceptance of restrictions and covenants and easements. There again, instead of us telling them the number of days, they need to figure that out. Most builders will probably want you to have covered your restrictive covenants before they get really far into building. But if the house is already partially constructed and they're moving on anyway, they might not have a problem with the buyer having 10 days or so to come up with the declaration of covenants and restrictions. We see that a lot of times at closings. I mean, you have the obvious, all cars must be parked in the garage. Someone buys the house and has a big van that won't fit in the garage. You've got a problem. So these are things you look at. The next one, the buyer's review and acceptance of the water supply and sanitary waste disposal. But once again, if you're used to dealing in communities that have public water and public sewage systems, when you go out into that little area outside the community that may not have that,
like Williamson County,
you need to be tuned in as the agent to be sure that your folks are inspecting for this stuff, to be sure that the property will properly perk and so forth. Now, typically a builder should have gotten their permits to be able to do that, but sometimes they get a little carried away with the size of the house and they call rooms different rooms instead of bedrooms. Okay. All right. Moving on, same thing, flood zone, but not getting into that any deeper because it's consistent with our other agreements. So we've added some language that within the designated time period, buyer shall have the right to terminate this agreement within the designated time period. We had to throw that in because things like, for example, the survey, you cannot see that until the house is finished. You can certainly determine the flood zone earlier in the stage, but that's something most lenders acquire, so it's hard to say exactly what day the lender will do that. The only federal law that applies is a lender must tell a buyer at least 10 days prior to the date of closing if the property is in a designated flood zone that would require flood insurance. So we've kind of left that generic and broad there on purpose. We took away the fact about the buyer having to make their objections within 14 days of the binding agreement date, for obvious reasons as I just discussed. Down at line 407, you'll notice that we've deleted reference to the Tennessee Residential Property Disclosure Form. A couple of reasons. One, new construction is exempt, and also I doubt the builder's been living in the house that's still under construction, so they'd be exempt on two categories. Todd pointed that out to me one day. Give you credit for that. Okay. Yes, ma'am.
What if you are the agent who is the seller who is contracted with a contractor to build said house? Do you still have? That doesn't exempt you from.
Well, it's new construction. New construction
as an agent, never exempt.
Right, that's what I'm saying.
Right.
So,
That's huge liability, but.
right, but I'm just saying, there's still, in that case, would need to be.
Well, it's not a Tennessee residential property. You as an individual are exempt, but you as an agent must disclose. And I guess the form you could use to disclose would be that.
Right.
But you're,
I'm thinking at some point, it seems to me that you would need that in your file, whether it's at the time of contract or at the time of closing, right? Or am I making
If
too much?
you're saying you're a seller and you're the agent.
And I'm the agent.
Yes, as an
And
agent, as a seller, you're exempt because you didn't live in the property. But as
Right.
an agent, you're not exempt. So are you asking what form to use to
I'm
disclose?
saying at some point, it seems to me that form is relevant, whether it's at time of contract or time of
You're
close.
speaking of the exemption form?
No, the property disclosure. The
Well,
full
and
property
you don't need to
disclosure.
use that form to make the disclosure. It's not that form that's required. It says, as an agent, you must disclose any adverse known facts, that you have actual notice or knowledge. It doesn't say, agents don't necessarily use the Tennessee residential property condition. I'm not saying you couldn't use it. What I'm saying is that's not the required form as an agent to disclose what you know.
Where Bobby's
Because
going
you're
with that,
exempt
yeah.
from the form as a seller.
Well, as
So you have to disclose it. What means you use to disclose it, I'm not sure.
You have the
Yeah, that's
agency
right.
requirement of the Brokers Act to make disclosures of
Right.
material facts that could have an adverse impact on value. Okay?
Right.
I mean, and you have that duty to both buyer and seller
Right.
as an agent. So, I agree with Bobby. He said if you're wearing an agent hat and you're also selling, you need to be extra careful to make your disclosures. But what we're saying is that the property condition disclosure report is probably not necessarily the form you would use. I mean, it's not, you're not required to use that form, but you are required to make disclosures. Now, if you want to use it, I don't guess anybody would fault you for it. No one ever gets upset when a seller's making disclosures.
Right, I mean, I like to be as.
Yeah.
And I'm not
Up
sure
front
that that
and
form, because it
inclusive.
wasn't created for new construction, it would really encompass all that would be,
Yeah, it's
I'm
good
trying to
point.
think of it, because it's not, that form is only if you lived in the property. So I'm not sure that form would be all encompassing of what you as a new construction seller agent would need to disclose. So it's not, that form wasn't designed for the
Right.
use. So,
Right.
you know, you could do it in a list, anything that you have proof that you have given that disclosure. Not sure we have one for that situation.
Right, I'm just, I mean,
But I don't think that form is the right form. And that's why we've taken it out. But yes, you're never exempt from.
it just has a lot of pieces about.
Oh, it's the scariest
You
thing
know what
I
I'm
deal
saying.
with as a broker, is agents
Mhm.
who are building and listing their own property. I lay awake at night.
You have a very fine line there, because during the phase of construction, certain things arise and you just, you correct them, but that's part of construction.
Right.
Right.
But if you're trying to keep your list, I would figure out a different way to make a disclosure other than using that particular form. I think that form would cause you more aggravation down the road, because you've used it, but there's, as Bobby says, there's certain things in new construction that's not even contemplated in that form, and those could have been some of the things that you should have disclosed. So you could very well think you've covered everything on the form, but left out something pretty material that was part of construction.
And I haven't really sat and gone over it, so.
No, I agree with what you're saying. And obviously that would need to be somewhere.
Yeah.
I'm just saying, I thought that the way to be most inclusive with the disclosure forms that we have was to do this one as well.
And without having it in front of us so that we could see how that applied to new construction, I'm not sure the answer is a complete yes.
You just want to be very careful and cautious that you just don't think, oh, I've answered all the questions on the property condition report, I've satisfied my obligations. as an agent to disclose material effects, because there could be certain things with new construction that's not in that agreement, not in that disclosure form.
Right.
Thank you. Okay, number 20 on page 8.
We've had a lot of fun with the new construction warranty. I guess as a background, there's Tennessee state law that addresses what type of warranty might very well exist to a builder that gives no warranty. The law will impose a lot of real requirements on you. As a result, through the years, builders have used what they refer to as a limited warranty. Problem is, limited is not some legally defined term that you can see in a book exactly everything that's covered. One builder's limited warranty may be very, very, detailed, and others may be a little slack on what they're doing. I've seen them exclude everything on the inside of a house as part of their limited warranty. That's their limited warranty. So what we've done here, and we spent a lot of time on it, because on one hand, we cannot define per se what the builder's warranty is going to be, but at least we start out at the very top of page 409 saying that the builder will at least construct the property at the top of that line 409 in good workmanlike manner, free of defects in material and workmanship. And we take a monumental leap and say for a period of 1 year, because that's typically what you see. Seller should provide within 3 days of the binding agreement date a copy of the limited warranty. Now, this takes a lot of thinking through, but to be at closing after you've watched the house be constructed and the builder hand you a limited warranty is not really a good time frame for the consumer to be seeing what the builder is going to be obligated to.
And it happens all the time.
Yeah.
So we balanced this, we discussed it, we came up with the conclusion that it was best to say, okay, let them get the contract, and there's other contingencies taking place anyway. That's time for the builder to actually produce the form, not the warranty itself. He's not warranting it that day. He's producing the form for the people to see. So, and there's a thing, seller shall provide within 3 days of the binding agreement a copy of the limited warranty, specifying the terms, conditions, and limitations of seller's obligations related to any discovered defects to the property arising during the warranty period. Then buyer shall have 3 days after receipt of that warranty to review and accept it as to form and content. We're talking about form and content. All right. Now, if the form is unacceptable, buyers will then have 3 days in which to terminate the agreement. Okay? So basically, you find out real quick if you don't like the form, at least give you an opportunity to go back to the builder and say, we really wish you'd give us a limited warranty on some of these things inside the house. Now remember, we're not talking about, at this point, manufacturer warranties. That has nothing to do with it. Manufacturers guarantee the oven or the dishwasher or the HVAC system, and that warranty's there just because to the
and
user.
nor are we talking about those third-party warranties.
Not yet.
That a builder, a builder can pay to be approved by these third-party warranty companies that actually take on the warranty of the property, and the builder's out, and the builder pays a great deal of money for those. And so when you have a concern or a claim, you deal with the third-party warranty company. Builder has to be approved for that. That is a whole separate, a huge booklet actually that's given by the third-party warranty that the builder's paid for. That's not what we're talking about. If the builder has that, then of course they would be able to do that, and that would eliminate the builder's responsibility. Thank you, Ron. I'm sorry.
No, fine. And then, of course, up to this point, right after the binding agreement date, this is only looking at the form. What's the builder going to give me when the house is completed? Then at closing, that's when the warranty begins. And unless there's something that the builder says, I'm not going to give you a 1-year warranty, I'm going to give you a limited warranty, I may only give you, a certain number of months. There's no mandated law that dictates, I guess, that because the case law talks about basically it can be unlimited for an unlimited specified period of time unless the agreement talks about a time limit. We've year here because that is the custom throughout the community. Very few people would argue that a builder's warranty would go anything less or more than a year. Now, warranties are for the 1 year, but we do have this little 10-day provision in there. It gives the buyer the opportunity, if they discover a plumbing leak on the 365th day, it gives them 10 days to get notice to the seller, the builder. This is, hey, I've had this plumbing leak. In other words, so that it's just a notice period. It doesn't give them a year and 10 days. It just gives them that extra 10 days to get the notice to the seller. They're also required to give reasonable notice of problems as the year is progressing. They can't wait till the end of the year because what's happened, things could have deteriorated and gotten worse. So the homeowner's got to step forward. So that's kind of how we address that. Then what Bobby was referring to, it goes into section 21. We call it an extended warranty now. We've taken the word builder out because it may not be something the builder is warranting. It may be, as she states, a third-party company that's giving you some type of extended warranty. What's gotten confusing is that there's a difference between an extended warranty where you have like there used to be corporations, they're still out there, that will extend the warranty beyond the 1 year if it's a structural defect, different things like that. So that's area. Every now and then we'll see someone address just the regular home buyer's protection plan that we see on existing homes. That's not really the type of policy you would get the first year because the builder is already responsible for the dishwasher and the heating and air, or the manufacturer's warranties are in place. So what are you paying for to have that home buyer's protection plan for 1 year? But every now and then I'll see where they've got a builder paying $700, $600, $500.
Well, some of the warranty companies are now for an additional a fee coming in and covering from year 2.
The second year, but that needs to be clarified.
That's why we put this in here, so that you can ask for that from a warranty. But we wanted you to realize there's really kind of 3 different kinds of warranties.
Once again, you just have to watch these concept of this warranty of, what stage the house is in as far as construction and so forth. All right, moving on. There's nothing further that's new. We've already talked about at line 528 why we've added section headings, and other was removed in the purchase sale agreement. So this is just consistency within the agreement. So that pretty well covered the new construction agreement, and I'm sure we'll continue to look at it, delve into it. You can always perfect things.
Did anybody wave over there? I didn't see. Everybody's cool? No questions? Great. Going on to the 203, we did cover this. We kind of jumped ahead. And this is that condition exemption, Tennessee residential property condition exemption. And again, I just want to reiterate that this now becomes just a disclosure statement from the seller to the buyer, and we have eliminated the required disclosures on here and made it its separate form, which I believe was the 205. Just reiterating what we talked about. Everybody's good with that? That's really a biggie, and I think it's we're now in compliance with what the statute requires. Okay, so then the next thing we're going to deal with is the 622, which is the backup agreement contingency. We found that especially in some of the areas where there's multiple offers or it's a very hot market, that sellers want to accept and negotiate backup agreements so that in case the primary should default or terminate, they have this automatic contract to go into place. But we also decided that that wasn't right to have them have to put up the earnest money before they went into the first position. Is that correct? So on page 90, which was page 1 of the RF 622, we have eliminated the places where it talks about the earnest money. If you can see all throughout, we are eliminating the buyer's need during a backup to deliver earnest money, just because it becomes pretty laborious in collecting it and getting it back. Is there anything I need to say more about that?
Does it clarify then at what point, I guess would it just revert back to when you go move into the primary position at that point in time, or this money is paid?
Well, then the contract goes into place and it would have the time frame. This is an agreement that if you are going to be a backup, you're going to negotiate. You need to use this backup agreement. It's a wonderful form.
Right, no, I understand that. I guess what I'm saying is, it's just, basically common knowledge then that because we removed earnest money from this, everything reverts back to the
contract.
Yeah, and then line 19 also addresses that in the event that the primary agreement is terminated. So that addresses that going into primary position.
Okay. So now we get to a little another heartburn situation. We have the temporary occupancy agreement, which casts fear in the heart of attorneys and agents and brokers. And that would be page 92, starting with the 626, which is the temporary occupancy agreement for a buyer to go in prior to a closing amendment addendum. And Todd, I'm going to set you up for this lovely form.
Thank you.
This is the buyer to the seller, buyer going in early.
Well, this one really ran red, didn't it, on the front page?
Well, how many hours did we?
We argued over this quite a bit. For such a conceptually easy concept, I mean, situation, it involves a lot of details, and there was a lot of unrest in terms of how the money was dealt with. Who's going to hold this deposit, all this kind of stuff, and just kind of walk through it with you. Of course, the first paragraph didn't change. The second paragraph, read with me here, and we can flesh this out a little bit.
It's very quick.
The compensation. Buyer shall pay seller as compensation for the use of the property from the occupancy date until closing a non-refundable fee of blank dollars, and the sum of blank dollars per day. Now, depending upon what your situation is, you may put 0 for a deposit, you may not. Maybe you put it all on the front end of a non-refundable deposit and you don't charge a daily fee. It's open to the parties to determine that. The compensation shall be paid upon execution of this occupancy agreement. So we're trying to make it clear that we get all this money paid as of the day we sign this thing. Any late payments would be subject to a late fee, which I suppose would come up if there was some sort of extension or modification, if there's a daily rate and later you extend it in some way. Buyer acknowledges and agrees that no part of the compensation payment shall be applied to the purchase price of the property. So this is money that you're paying for the privilege of being there, end of story. Now, the whole deposit money section, we pretty much gutted, I guess. And from my perspective, it was just a little bit too complicated, and it involved agents in a lot of cases as the holder of this money and dealing with it in terms of, is it going to be credited at closing, which had issues with lenders, and getting into disputes. We tried to make it very clear that, look, you're going to pay this money, it's non-refundable. That's it. That's it. So we're not going to be doing this thing of allocating money back to you or applying it to closing or giving it to you at the closing table, something like that, because that caused a lot of heartburn. The other thing that was causing heartburn in this, and then also in the other form we're going to talk about, is what happens if it doesn't close, if there's a delay or something like that. And so we added the word default to paragraph 3, so failure to close and default. If the buyer should fail to close on the closing date for any reason, buyer agrees to vacate the property within so many days without further notice. So get out. If you don't close, you got to leave. And it doesn't require me to give notice or anything further as the seller. The buyer agrees to restore the property to the same or better condition, and basically they're held responsible other than just normal wear and tear. And it goes on to say, if the buyer fails to close by the closing date as agreed, and continues to occupy the property. And remember, that continued occupancy is, I mean, they're in default at this point. We've tried to make that clear. Such occupancy shall be at the sole discretion of the seller and will be at an increased rate of so much per day in compensation to the seller made payable without demand, or the buyer shall vacate the property. And again, the buyer's responsible for the payment of all costs and expenses, including attorney's fees, if they have to be evicted. So I guess at the end of the day here, we've really kind of clamped down on this situation, hopefully to make it clear that, look, if you don't close, you have no right to be here, get out immediately. We don't have to make some notification, demand, or anything else. And if you don't get out immediately, we have the right to go have you removed, and you'll pay for those expenses. Yes, sir.
I have two questions. My first is, as an attorney, what's your opinion on the maximum length of time that this type of form should be used before you go to an actual?
Never.
Yeah. As I say, as an attorney, I'd say never use it and don't do it.
This forms have a lot of dust on it.
This is a pretty exceptional form, I think. So I would say, I mean, me personally, week or two is a ballpark. I'm not seeing this as anything that you should go more than just, it's kind of a hardship situation is the way I view this. There's
really hardship.
Yeah, there's something that's happened and all the circumstances line up to where the seller's willing to do it and they vacated, and I'd say this should be the exception. And if it's going any longer than a week or two, you really need to, I don't know what you think about it, I think at some point they start to look like a tenant.
Yeah. Oh, no, I agree.
And even though we say they're not to be considered a tenant, I don't know what a judge would do with that if we try to use this thing for an extended period of time.
So you have the
and it's not
Landlord-Tenant
specific
Act.
enough. Yeah.
The Landlord-Tenant Act applies in 18 counties now in the state, and
yeah,
it puts a lot of additional obligations on the landlord if you have a landlord tenancy.
Isn't 19 days
Yeah.
19 days goes into long term?
I'm not positive about that. I just know that you need to be very careful not to, on the other form where the seller's staying there after closing, they're pretty much going quick. But you could have a situation where a buyer's moved in early, got in possession, and then they don't get approved and they just keep staying there.
Right. Well, and this also specifically states that this doesn't create a landlord.
it does. It does specifically state that. I just don't know what a judge might say.
No, I was just curious your opinion on that.
I've never really honestly researched that because, again, I discourage use of the form except for very exceptional situations where it's confined to a relatively, small period of time, and
So
even then it's
Todd,
risky.
What happens if on a Friday we don't fund and that was the closing date and we know the money will be there on Monday? Do you think you need to have one of these forms for
You're really teeing this up for me, aren't you?
wondering if on Friday, if
Yeah.
it's going to expire and they're going to get, and it hasn't closed, what would
Yeah.
you have to do on Friday to make this all work right?
Well,
You'd have
you'd
to
have
have,
to execute it.
you would have to have an extension.
Yes. So, and look.
There's
this-
no such thing as a dry closing in the sense that
Right,
it's not
right.
a closing, right?
And this is tacky, but I use it. It's like being pregnant. You're either pregnant or you're not pregnant. You're either closed or you're not closed. There's not sort of a closing, right? That's the way it is. So yes, on Friday, if you're not closed per the contract, you've
You
got
mean
all
the
sorts
money
of,
has,
yeah. So the money hasn't transferred. There's funding conditions remaining. You've got all sorts of things. Ethically, your job is to keep contracts extended. I forget which article it is. I think it's 9. It says your part of your job ethically is to keep keep your contracts extended and keep your deals alive to the extent that you can. So you'd want to extend your contract through the following Monday. That might be a situation where, if the seller's out and the seller's amenable and they get good and comfy with the fact that the money's there and everything's done, it's a mere formality, then that might be the situation where you use this thing. And that's probably, frankly, for me, where I would confine it. Is that sort of what you're going for?
And so the second part of my question there, we've all established that nobody likes, actually having to use this form, but Let's say you've got a situation where you know on the front end, before you go under contract, that this is going to have to go into place for whatever reason on the back end. But what would you advise in that situation? Because if I sign this when I sign the contract as the buyer, I have to put up whatever that amount is, because that's what it says, you know, within the confines of this. But let's say I go through my home inspection and decide I don't want the house anymore, but that's not refundable.
Well, if you go on page
Yeah,
2, there's a, I'm sorry, Tom.
no, I was gonna say there's additional terms.
Additional terms. So you know, the printed word or the written word supersedes the printed word. So consequently, if they did modify it, you have a place to make that money.
Yeah, so you might want to, I mean, first off, there's nothing that says you have to have a large deposit amount. That's negotiable. Or you could put a deposit amount, but as Bobby said, go to the additional terms and say that, look, it becomes non-refundable only following certain events or at a certain time. Okay. And so I guess that's the way you would deal with it.
Yeah, that's what I was looking for.
Yeah.
Because with the word, you know, non-refundable being put in there now.
Yeah, and we you know, we leave that additional terms section there for that very reason. It's awfully hard to design a form that fits every situation. It's almost impossible. So you have to leave a little bit of room there.
But at the same time, you're extending the contract from Friday afternoon. That's a good time for that other special language paragraph that says you're increasing the earnest money. And but now we're back over to the earnest money concept, and that becomes non-refundable. Or
that might be a really good thing to be able to do.
Versus here in this agreement, you know, you're not talking about a large amount of money, just something that.
This is where our value comes in, because by knowing what forms and how they all feed together, that's about 3 different forms that would come into play to really tighten that up on that circumstance. And it's our job as agents to know what we have the ability to use and to educate our buyers and sellers their options and how this comes together. I think sometimes we just think, well, it's just the weekend, they can move, and then there you are on Monday with a real problem.
And it's not a problem unless it's a problem. And then,
right.
So that's, I'm preaching to the choir here, I know.
Yeah, we've got a YouTube question. I think we've touched on this a little bit, but there is a slight delay with the channel. It says, it has been brought up in the contract courses that eviction is not a part of this document as it is a contract dispute. Is eviction possible? How about tying in a lease?
Well, I think the whole point is not to want to have to go that route. We really went to great lengths to not create a lease situation just because the eviction process and the Tenant Landlord Act have some really more elaborate and rules and regulations as to how to evict. So we tried to keep this completely away from. If you're going into a lease, as Todd said, over a couple of weeks, then maybe you do want to go into an actual lease situation.
Right.
But normally, we're not encouraging that.
Right. There's, on the next page, there's a couple of things. We've talked, well, we spoke about additional terms, but if you look at paragraph 8, we removed a part of the verbiage there, essentially to try to make it clear that, look, Mr. Buyer, you're not supposed to do anything to this property without consent. Period, end of story. It's almost like we were sort of addressing something that we're discouraging them from doing anything, but at the same time talking about how we're going to let them do it if they choose to make improvements. We're speaking out of both sides there. So we took out the part that says the buyer would pay for any sums expended and not receive any refund or credit. Essentially, if there's going to be any sort of improvements or alterations, you're going to need to deal with that in the additional terms. And
yeah, maybe the seller's going to let them paint while they're in there. But again, that's another caution.
So that's pretty much it on that one. The companion form, if you will, for that one is the one where the seller's going to remain in the property after closing. And there was some concern that the verbiage that was in this form sort of implied that, you know, it was okay if the seller needed more time and just decided to stay. We tried to clarify to say that, look, it's a default if you stay beyond what you agreed, what we agreed to let you stay. It's not that you now have this ability just to continue to stay there. You're in default. And the way that we did that is just to change a little bit of the verbiage here. The way it reads, seller shall pay to the buyer as compensation for the use of the property the sum of blank dollars per day after the closing date until the agreed upon possession date. Said amount shall be payable from the seller to the buyer at closing. So we're going to take care of it that day. In the event the seller defaults and fails to deliver possession of the property on the possession date, the compensation shall be increased to so much more per day and shall be payable without demand by buyer. Seller shall have the seller shall be responsible for payment of all costs and expenses, attorney's fees incurred by the buyer resulting from that default. So again, the goal here is to make it clear that, Mr. Seller, you're here at the buyer's leisure. You've agreed that you'll get out by a certain date, and you're expected to do that. And if you don't, it's a default. I think that was always the intent, frankly, of the form, but I think it needed a little bit of massaging to get to that clarity level. So I believe that was it on those forms, unless I'm seeing something, overlooking something.
I did want to make a note in our booklets for today. Some of the added sentences are in green. That is the same as blue. I don't know why some are green and some are blue, but you can consider green blue. Maybe
green is the new blue.
Or if you're colorblind, maybe it all looks green.
Maybe get ready for the season.
Hard to say. I can't tell the difference anyway. So
okay, so I just want anybody to think when they came across green that was something else. Blue or green are the inserted sentences and paragraphs. Red is the deleted.
I was wondering about that.
Well, I didn't want anybody to be concerned.
Mm-hmm.
Okay, so Todd, you did an absolute fabulous job, and because of that, you get to continue.
Thank you. Thank you so much.
Anytime.
So the next one is Form 623, and it was seller's right to continue to market property. Before we didn't feel like it told the whole story, so we changed the title slightly. Buyer's first right of refusal addendum, parentheses, seller's right to continue to market the property. So it really sort of tackles both of those issues, and we were trying to make that point with the title. And I guess I would say that we changed the way this form looks. If you look at line 9, we sort of did these indentations and added numbers to make it a little more clear. Some of this stuff was just kind of frankly in a paragraph jumbled together, and it was very easy to overlook and very easy to misunderstand. So we did all of that to alleviate that issue. The first substantive, what I would consider substantive change, would be line 11. And you can see for yourself, we took out the word only and delivery. Delivery because, frankly, we don't use delivery anywhere else in these documents. Yeah. And it was rather confusing. It's as if we had changed course on this one form. So for purposes of this addendum, any time reference shall be measured in calendar days and/or hourly increments and shall commence upon receipt of notice. There are no delays for weekends or holidays. So we do, we deal with whether there is an automatic extension. If it expires on the weekend, we deal with that. There's not. We try to stay consistent with all of this keying off of when something is received by the
rather than
party.
how we do in the binding agreement date, where you start counting the day after.
Mm-hmm.
We wanted this to be an isolated, so that it starts your time frame from the moment it's received. So, like if you've got hours, because usually we've got hours. It's the form usually says somewhere in here.
Yeah, there is.
You have a place on line 17. Sorry.
No,
where you always put in hours, so you can't start counting hours the next day.
Right.
So you're counting them from the actual receipt.
Right. And so we leave the space there. It could be 48 hours, it could be 72 hours, it could be whatever you want. But typically, like Bobby said, we're dealing with hours here, not days. And so you would start counting essentially when it's received by the recipient. Let's see, that was the main change on that page. If you'll flip to the next page. The failure to remove contingency paragraph, which is paragraph 7, has been modified slightly. If the buyer fails to remove the contingencies identified in section 4 above, or fails to respond within the hour period provided, this agreement shall become null and void, with earnest money to be returned to the buyer. So basically, failure to respond, failure to remove would serve as essentially it self-terminates. It's considered null and void at that point if the buyer doesn't step forward and actually make that that representation or remove that contingency. A little bit further down, we sort of reoriented paragraph 9 to, again, hopefully make a little more sense. Since we've done this numeration of all these paragraphs, we had to change our numbered paragraphs to lettered paragraphs. These are some of the nuances that I'm thankful that I don't have to think about, but I'm glad somebody does, because it makes life a lot easier. So we're going to check the following boxes. Notice we added the sections not checked are not a part of this agreement. So again, trying to remain consistent with the way we treat all of our documents and all of our check boxes. If you don't check it, it's not part of the deal. Let's see, the verbiage itself didn't change, except down in D, we had to specifically refer to section 4, which is where you would write the contingencies that would be removed. And again, I guess the main thing I would say, and Bobby, you may have commentary on this, is this section really needs to be considered pretty heavily when you're using this form as to what the effect's going to be if you decide to remove it. How does that affect your closing date?
Well, the point was, it's not just somebody calls and in 72 hours they say, yeah, we remove it. Mm-hmm. There has to be some proof or some responsibility to show that they can, and this allows the seller, because this is going to be probably a form that goes from seller to buyer. Mm-hmm. Buyer would not necessarily, they could. But, and if you were wanting to look really strong in a multiple offer and you had a contingency, this might be the form. But normally this is going to be from a seller to a buyer. And so what we wanted to have is the seller to be able to check some boxes to give them some extra reassurance that this buyer really can remove the contingency and going forward. So if you read these, it gives those kinds of things. It even allows the seller to say, okay, if you're going to do that and you're so sure now, your money's non-refundable. So it allows those kind of comfort clauses so that the seller feels good about letting their offer go and letting this one go into the ready to go position. So that was our thoughts.
And paragraph 10 just clarifies that if the buyer does wish to proceed to closing, the buyer has to, within the number of hours specified, notify either the seller or their licensee in writing, advising of the removal of the aforesaid contingencies and their willingness to proceed to closing. So that's the means by which you would do that.
And it just so happens. On the next page.
that we provide a mechanism for that, for those actions. And so kind of look at this seller's notice to buyer of acceptable offer. Again, just clarifying at the top, it's between the buyer and the seller to the property address. And the first notice is in that, between the two first bolded lines there, notice from seller. Seller hereby gives buyer written notice that seller has received another acceptable offer. Buyer is expected to respond to this notice no later than the time set forth in the buyer's first right of refusal addendum. We don't make them restate it again for fear that they screw it up or they change it, and all of a sudden it creates this, differential between what was agreed upon versus what the seller is demanding. And then the seller, of course, would sign there, and that's the form that would be forwarded to the buyer, the buyer's representative. Well, what does the buyer do? Well, there's a buyer's response section which starts on line 18, and by signing this, there are two options: close or no, I'm not going to remove my contingencies. So the first option is by signing option 1, the buyer agrees to waive the contingencies contained in the first right of refusal addendum and close as specified in the addendum, or if silent, according to the purchase and sales agreement. Because you may not have indicated some difference. Maybe you didn't check the box concerning the closing date. So you would refer back to the original contract as the closing date, for example. So that's one option. Or the second option is the buyer declares that he cannot or will not remove the contingencies, and therefore would be terminating the contract in essence. It would be the buyer's obligation to get that over to them. Particularly, I'd say it's particularly crucial if you're choosing option 1, because if you want to close, you need to notify them, because the way this thing works is if you don't do anything, if you fail to remove those contingencies, you're deemed to have the deal's over. So I guess it's particularly crucial if you want to stay in the game to make sure you get this option 1 notice sent over. And there is a place at the bottom for seller's receipt that you would want to ask the seller to acknowledge receipt of the notification. So,
you know, and it looks a little maybe laborious back and forth, but the most important thing as agent is that we have some sort of confirmation and paper trail of how we got to a certain place. And our whole purpose is to assist brokers and, of course, agents in making sure that they stay pretty consistent and out of trouble. And knowing your contract, knowing what's available to you, and using all these forms cohesively is going to make all the difference in the world to anyone when you do go before in a court of law or try to defend a search situation. And that's what makes me so excited and proud of being a part of the forums. I've been on it for years and years, off and on, and every time we do it, we learn more. And I think Tennessee has some fabulous forums now, thanks to these two attorneys and Addison, who is unfortunately ill, but she answers the hotline questions when you call. And so she is in the trenches getting those questions. And so all of us singing on the same page is really, really important. And maybe we can clear up some misinformation. Well, do you have anything to say for yourselves? More?
We're 13 minutes early.
I really want to thank everyone who participated today here in person. It was really great to look out and see some faces rather than just a screen, so thank you for being here.
Thank you for all your work this year, Bobby.
Oh, I
You've done a
enjoyed
great
it
job,
so
Bobby.
much. And thank you to those in the field out there. I understand there's 90 of them or something.
Yeah, we had 90 viewers at one point on YouTube.
Wow. I'm going to have to check this out. I may have to take it down if I don't like it. But I do want to, I appreciate, because from those 90, 80, 100 of us, it's our job now to go out and make sure that the rest of the agents, brokers, and companies are all doing it correctly. So thank you. And
Question for you.
yes.
These come out January 1st?
Yes, I did. Thank you for bringing that up. These are wonderful, and they're great for us as brokers. However, when they come out in January, all those numbering is going to change, because once they remove all the red lines and fit that, it's going to all format differently. So this is for you, but you're not going to be able to use it line by line with the new ones that come out. And Sarah, I would like to introduce you. You want to come up? And thank you. Sarah has done a phenomenal job today. She was thrown into this pretty quickly, Buzz Steele, who's been with us for, what, 40 years, 30, 100. We have always worked with Buzz, who does all the formatting and gets us ready for this. He was with us until the end of October, and he now has taken a position as an AE with MTAR, Eastern Middle Tennessee. And so Sarah was brought in at the last minute practically, and she has put all of this together and did a beautiful job. And so
Excellent.
we're very, very
Could not have
grateful.
done it without you guys.
Now, she is the one that's going to be responsible, or it already did get sent to the official place where they make it into the formatting.
Yes. It's all done and they'll all be published in January, hopefully the 1st, you know, barring no issues with that. But yes, definitely they will be available in their full format in January, and your transaction desk will appear, the 2018 folder will appear, and you'll see those forms on that day.
And Todd and I will start, and Ron will start teaching this in January.
ASAP.
We're kind of, are we teaching it fully this new next week?
No, I'm waiting until the first week of January, when they actually come out and the agents have access to them.
Yeah, because if we start teaching this now, I don't want them to get confused. So that confusion is the worst thing in this industry. So I have nothing more to add. Denise is going to take over the Forms Committee next year. So she's made some notes that have come up from today.
Yeah.
So she will have her work cut out for her. And it was an honor to work with you. And she takes the most detailed minutes I've ever seen.
Oh, so if you're bored and you want to know everything that happened, just let me know. I'll send you the minutes.
Yeah, it's pretty intense. It's pretty intense. Some people don't like us, but we like them.
We get along.
Yeah, we do. Thank you all for being here, and we'll see you in the field. 2018, here we come. Woo.